On December 3, 2022, agents from the FBI contacted the Arkansas State Police to request that a traffic stop be made on Johnson County Sheriff James Stevens, who was driving along US 71 in Crawford County, Arkansas. The FBI investigating Sheriff Stevens after receiving tips that he may have been engaged in organized corruption. Trooper First Class Matthew Price located Sheriff Stevens' vehicle with the FBI and initiated a traffic stop for speeding. The interaction that followed was captured by the trooper's dash camera. I'm an Infinite Sports Supply Charger 7990 should have 7990. Should have. Hello, sir. What's up, boys? Hey, I'm Trooper Ross. State Coming up, flashing lights there. You were speeding just a little bit. My flashing lights. There used to be flashing lights. It's a 71 to 82. How fast are you going? You're going 50 in a 45. Not that big of a deal. Not too bad. Yeah, not bad. Do you have your license on you? Yeah, I do. Registration and insurance. This your car, well, it's the county's. The county's, yeah. What, you work for a county department? Yeah, Johnson County Sheriff's Office. Oh, okay, glasses. How long you been with them? I got my gun on my side too. Okay. Yep, service weapon. I've been the sheriff for the last 4 years, okay? Alright guys, we're gonna have to bear with me. I know we just got the insurance on a couple things. What are you doing up here in Crawford County? Well, I went to visit a CI. Visit who? A CI just north of town. I delivered some bags of goodies up there. What did you deliver to him, Well, his wife. Let me pop the truck and I'll show you. There's some goods at the co-op deal we did, yeah, where it's, giving out there's a company needy thing. Hey, if you don't, since you're hopping out, weapon over the passenger seat, come back here, all right? There you go. So you said you meant to see a CI, yeah? What, like a confidential form? Yeah, but I mean, that's what were you taking him? These are things that we put together, little care packages for homeless. Or not, well, people in need. Oh, really? Things are like that, yeah. So why is your CIA in Crawford County? Well, I got them in Crawford County. I've got CIAs and I got one in Sebastian County. Got the Franklin. Pope, they Johnson, they just drive to Johnson to work or what? No, there's people that we get the permission for. People have known a long time that it's kind of weird. We get information. Well, it's kind of different. I work narcotics a lot, but yeah. I hear of people having CIA stuff, but I've never heard of them out like a sheriff or sheriff from outside the county that works outside of Johnson County, you know what I mean? We do it, brother. Do you? You back, you do it as sheriff. Of course, hands on, brother. That's the only way to go. Yeah, you got hard that's charging. Awesome. When questioned about his business in Crawford County Sheriff, Stevens told the troopers that he was in the area to deliver a care package to one of his quote-unquote CIs, or confidential informants in law enforcement. A confidential informant is an individual who provides information to police regarding criminal activity, often in exchange for money leniency or the dismissal of pending charges. These relationships are designed to grant officers access to communities and criminal networks that would otherwise be difficult or impossible to infiltrate. However, informants also occupy one of the most legally and ethically complicated roles in modern policing, as their reliability and motives are often highly questionable. Rather than being codified into a singular federal statute, the use of confidential informants is governed by a patchwork of agency policies, constitutional constraints, and judicial precedents. The Supreme Court has repeatedly affirmed that information from a reliable informant can justify a warrant or arrest when corroborated by independent evidence, most notably in the 1983 case of Illinois versus Gates, now in Arkansas. The use of informants is primarily guided by departmental procedure rather than statute. While there is no law explicitly dictating how sheriffs or police must manage their informants, Arkansas Judicial President mirrors the federal standards established in higher court case in Arkansas. Courts routinely examined the reliability of informants and whether officers independently corroborated informants' claims before for taking enforcement action. Furthermore, the legal framework established in the Gates case presumes officers act within their lawful authority when using an informant, and Arkansas sheriffs or county officials, meaning that their enforcement powers are generally restricted to the territory of their own county, unless extended by law. Therefore, Sheriff Stevens' explanation that he was merely delivering a care package to a confidential informant was inconsistent with established legal and procedural norms, as he was outside his county and therefore his jurisdiction, and rightfully garnered more suspicion from Trooper Price. So you just up here fixing to head back to Johnson? Pull it here, pull and buy a knife. And then head back home. Yep, got a parade at 5 and head back? Yeah, okay. Well, this is one of my new guys to let just talk with him for just a second. We'll get you out of here. You don't have no more guns and like that on you. Okay, give me 1 second, all right, buddy? He's up here seeing a CI out of Johnson County. Taking him a thank you back, never mind. They're down here. Find anything FBI? Okay. Any other weapons on you at all? Nope. In the car. No backup weapon anywhere? Nope. Okay. Hey, Sheriff, let me ask you this. You don't have nothing illegal in your car, do you? Nothing. You're not supposed to have no drugs. There could be, yeah, there could be drugs in there. There is. Definitely, yep. What kind of drugs? There's some, my CI just gave me some things, what it was. Passing, there's some little, I don't know what things are. There's some butter and, like marijuana. So yeah, and like a butter marijuana and 2 little buds, that, through the course, going on, I don't care, no one talking to me. Hey, go ahead and put your hands behind your back real quick, okay? Trooper Price detains Sheriff Stevens after he admits that his vehicle contains illegal drug suspects. Voluntary admission of criminal conduct, particularly the possession of a controlled substance, constitutes direct evidence of a crime. Under both federal and state law, that admission alone provided an independent and sufficient basis for Trooper Price to detain the sheriff, regardless of any parallel FBI investigation or pre-existing intelligence. The Fourth Amendment allows an officer to detain an individual when articulable facts give rise to reasonable suspicion that a crime is being committed and authorizes an arrest when those facts develop into probable cause. In the 1976 case of United States v. Watson, the Supreme Court held that a warrantless arrest is constitutionally sound when an officer has probable cause to believe that a felony has occurred. Arkansas courts have consistently applied that same principle, holding that a self-incriminating statement, when made voluntarily and corroborated by context, is sufficient to justify immediate detention. By acknowledging that his patrol vehicle contained controlled substances, Sheriff Stevens effectively confirmed an ongoing violation of Arkansas Code 5-64-419, the state's possession of a controlled substance statute. That confession supplied Trooper Price with an objective, articulable foundation to detain and search Sheriff Stevens, which was totally independent of the FBI's request for assistance. This whole deal's odd to me, and so as of right now, I'm gonna go entertain. You okay? I'm not saying you're under arrest right now, but as of right now, we're just gonna entertain until we figure out what's going on. Okay, Sheriff, I've never heard that you what you're doing is wrong, but I can tell you this. I've been working narcotics for 7 years, okay? And I've never heard of a sheriff himself coming out. I'm not saying it don't happen, because it does happen. Very often it comes out and works. Narcotics on his own and stuff like that, okay? And now that you said you've got some narcotics in the car, we're gonna search your car, okay? Is this your personal car? Is this your... No, this is a county-owned vehicle, okay? Does the Corn Court and all them, they allow you to take this out for personal use? And I wouldn't quite call it personal use. want to zip your jacket. Go ahead, okay, here we go. Let me ask you this, do you think if you were in my position, would you think this is odd? Trooper-based. I'm talking outside of what if they've been here? Look at me. Are you talking to me? I'm with you. I'm going to go ahead and just go to my rights, and I'm going to speak to attorney and assume I'm under arrest and you guys okay? I'll be respectful and do whatever you need to do, okay? Okay, I'm going to let you have it right here. Okay, all right. Y'all want to watch him for a little bit, okay? Hey, let's get gloves. Look at that left door right there. Okay, right, there is what was described as some kind of a... So open it up, and these, no, those are just bread. I don't know if they are. I'm gonna check. In this door, yeah, that's in the doorway. There ain't nothing in this pocket. Okay, yeah, I got them, yep. Hey, since you tell me where those are, you want to tell me where the bud is? Since you told me where those are, you want to tell me where they're in the truck, okay? I put them in they're in a plastic bag, okay, a trash bag, okay? Oh, I smell it now, oh. Damn it, son. What's that, huh? That's a lot of wax. Butter wax, still a lot. Yeah, would you listen to the right one, just attack on the purpose? Let me feel it, this one, no, the right one. Oh, the right one. It's twisted, you good. 324782. Hi, I just want to let you sit over here. Okay, I'm gonna put you in my car. You know your right to remain silent. Anything
Canon
you say
will be used
of
against
law,
you
you
in
have
a
the
court.
right to an attorney and
You
to
say
remain
Canon
silent.
will have
Of
anything
anything against
an
you in a
attorney
court
and
of
to
law,
remain
you silent. You understand all that I do, sir. Okay, let me ask you this. Would you like to talk about anything we found in there so far? No, I told you everything. That was in there. Well, I'm asking, do you want to? No, there's an explanation for everything that's in there. I'm asking you, would you like if I ask you some questions, would you be willing to talk about it right now? No, I'm not. I'm good, thank you, yep. Trooper Price asks Sheriff Stevens if he would be willing to talk about the illegal substances that were found in his vehicle, and the sheriff declines his request and verbally invokes his right to remain silent. In the 1966 case of Miranda versus Arizona, the Supreme Court established that suspects subjected to custodial interrogation must be advised of their right to remain silent and their right to counsel. Once those rights are invoked, all questioning must cease at least for a significant amount of time unless the suspect reinitiates communication or waives the invocation voluntarily. This standard applies to anyone in police custody, regardless of whether or not they are a public official. The court later clarified in the 2013 case of Salinas versus Texas that the privilege against self-incrimination is not self-executing, meaning that a suspect must expressly assert their right to silence in order for it to apply, by clearly and verbally invoking his right to remain silent. Sheriff Stevens triggered the protection of the Fifth Amendment, and Trooper Price's decision to end the interview at that point was consistent with both federal precedent and Arkansas case law. Any continued questioning after an explicit invocation would have risked suppression of the statements and any derivative evidence obtained thereafter. I love you. Stop for a minute before we get there, we'll talk. You okay? Yeah, I'm okay. Hey. You really are tight though, brother, okay? I found your wallet. Is there anything else in there that want to take with you? Probably just I think there's some checkbooks that was in your wallet, okay? There's 2 more checkbooks. And oh, thank you. Yeah, much better, thank you. Let me grab it. All right, thank you. Oh, my cover that game, all right, I'll get you, thanks. Sheriff Stevens was arrested and charged with speeding, 3 counts of drug possession, and 1 count of possessing a firearm while also in possession of drugs. Following the stop, the Arkansas State Police, along with the FBI, launched a broader investigation into former Sheriff Stevens' activities. On October 25, 2023, Sheriff Stevens entered a plea agreement in Crawford County Circuit Court, where he pled guilty to 1 count of possession of hydrocodone, which is a Class D felony under Arkansas Code 5-64-4. 19. Mr. Stevens ultimately received a 6-year sentence, but that sentence was suspended subject to conditions, including $10,000 in fines and court costs, and the surrender of his law enforcement certification. The prosecutor who negotiated the plea agreement stated that, quote, Mr. Stevens was given the same treatment that any other drug user would get in our county. However, the main focus was permanently removing Mr. Stevens from law enforcement and public service following his resignation from the department chief. Deputies of the Johnson County Sheriff's Office assumed operational control until the county's quorum court appointed an interim sheriff to serve the remainder of Mr. Stevens' term. As of the writing of this episode, Mr. Stevens remains classified as a convicted felon, with which under Arkansas law renders him ineligible to serve in any elected office or in any capacity as a peace officer. Overall, former Sheriff Stevens gets an F for blatantly abusing his authority for his own personal gain, engaging in flagrant criminal activity while serving as an elected official, and for betraying the trust of the citizens of Johnson County and the integrity of the Johnson County Sheriff's Office. Former Sheriff Stevens' conduct represents one of the most serious breaches of public trust that a law enforcement officer can commit. As the highest-ranking law enforcement official in Johnson County, he was responsible for setting the standard for ethical behavior and ensuring that his deputies upheld the law with honesty and discipline. When a sitting sheriff is caught transporting controlled substances across county lines, it can't simply be attributed to a lapse in judgment, and it should constitute the only evidence necessary to deem that official unfit to serve the public. Mr. Stevens used his authority as a sheriff as a shield for criminal activity and demonstrated a complete disregard for the ethical and procedural standards that form the foundation of public service. Perhaps the only silver lining here is that Mr. Stevens was eventually caught and then barred from ever working in any public service capacity while his sentence was ultimately suspended. The damage to the credibility of the Johnson County Sheriff's Office cannot be overstated and his conduct grossly undermined. Every deputy who serves Johnson County honestly, as well as every citizen who depends upon their fair and lawful enforcement, this interaction highlights the danger of unchecked authority within law enforcement and the importance of holding public officials to the same, if not higher, standard of accountability as the citizens that they are sworn to protect. Trooper First Class Price, along with the unidentified FBI agents, get an A+ for conducting a thorough and well-executed investigation, ensuring the integrity of the case by gathering hard evidence, and for maintaining a firm but professional demeanor throughout the encounter. The FBI's choice to coordinate the stop through the Arkansas State Police was both practically sound and procedurally correct, as it removed any appearance of bias that could have arisen from an in-county arrest. The decision to let an uninvolved state trooper initiate the stop protected the legitimacy of the investigation, and it helped guarantee that the case against Mr. Stevens would survive later scrutiny in court. Every step of the encounter, from the traffic stop to the arrest, captured on video, and the evidence collected was clear, corroborated, and handled according to lawful procedure and policy. What stands out most to me about Trooper Price's conduct is that he developed probable cause entirely through his own questioning, without having to rely on any prior intelligence or pressure from the FBI. His observations and dialogue during the stop directly led to Mr. Stevens admitting that there were illegal drugs in his vehicle which supplied all the justification that was needed for a lawful detention and search equally. Important was how Trooper Price handled the interview after the arrest. When Sheriff Stevens invoked his right to remain silent, Trooper Price immediately ended the questioning. That decision reflected a clear understanding of constitutional procedure and prevented any claim that the sheriff's statements were coerced or improperly obtained. The FBI agents also deserve credit for their restraint and professionalism. They allowed Trooper Price to take the lead, and they intervened only when necessary in order to secure the evidence and maintain chain of custody. Their coordination ensured that both agencies operated seamlessly and that the evidence collected would withstand the scrutiny that accompanies a case of this magnitude. Trooper Price and the FBI agents demonstrated how disciplined, cooperative police work can dismantle corruption without undermining public trust. And I commend them both for their excellent police work and their unparalleled professionalism. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments down below. Thank you for watching. And don't forget to check out Audit if you're interested in exploring the legal nuance beyond the body cam.